Okay.
Good morning. We have Senator Williams here to introduce S5. You have the honor of being the first senator to introduce a bill this session in this committee. So
Perfect. Is it S5 or S3?
S5, just the numbers got mixed up. S5, S3 is a different bill, but
Okay.
S5 is so floor is yours. And
Okay, I'm gonna read this. It's 13-page bill.
Oh.
Been around for a while. Actually, it started in 2022 with Senator can't think of his name, and it's been kind of involved through the Health and Welfare Committee. Finally got to the Judiciary, where it probably belongs. It's called the Guardianship Proceedings hereafter known as the AGE Act, Adult Guardianship Equity.
Senator Williams, just for logistics purposes, we do have until about 10:15.
Okay.
We just wanted to get like a general overview, and then we'll have Ledge Council come in and do a walkthrough.
Okay.
But he wasn't available today.
Right.
But yeah, just wanted to hear from you about what the problem is, what we're generally
Okay.
trying to resolve.
So I'm gonna read it. I actually prepared it, and I know it's gonna take probably 15 minutes, but I'm not gonna get into the 14 differences between, the problem is the difference between the probate court system and the family court system. And the differences are pretty significant.
The chair. Yes. I think what the chair is trying to say is we don't read the bills.
Okay.
We just talk about it. And,
Okay.
and tell us what.
Yeah, we will have Ledge Council come in to go, line by line on everything. But just wanted to hear from you about, the what caused the bill, and if you want to come back another time, you can get some more
All
detail.
right, well, let me change the way I was planning on doing it. So I think the whole crux of this issue is that it's because the probate division is a court in which individuals without disabilities may have guardianships granted for themselves. The current requirement for guardianship proceedings for certain individuals with developmental disabilities must be held in a family court division. Instead of the probate division, may be at odds with the common benefits clause of the Constitution. So, and if I had the time to really get into it, I would have explained it. But that's the main issue. Is that we think that Vermonters with that are granted that have been granted guardianships that are voluntary. And the difference between that and the involuntary guardianships. And, the involuntary guardianships are not available in the family court system. And they've got 600, I think Dale has control of those individuals, and there's 600 of them that possibly could. So, and this comes from an individual who was back in 1978, I think, that it was mental retardation. They changed the term, and basically this individual was able to go to high school, and she was originally put in an involuntary guardianship. The parents finally went to probate court and got her approved for a guardianship that was voluntary. And she went to high school. She had a job, worked her way through school, got a driver's license, and is a productive member of the society. And because she was originally put in an involuntary guardianship program, she's lost some of her constitutional rights. And for example, one, she can't own fire because she was in an involuntary guardianship program. And he wants to be able to have a firearm and defend herself, and now she can't. So that's a 30,000 foot view of it. But we'd like to see, whatever is in the family court system, for guardianship put into, so everybody can have an option to have a voluntary, guardianship. In the probate court system, from what I'm told, I've talked to a couple different probate judges, they have the bandwidth to pick up additional cases.
Pick up the involuntary part.
And, I've got, matter of fact, our district, court judge, the, probate court judge, I went and talked to him and said, yeah, we'd be glad to take it. And I know the family court division is backed up with, still COVID related issues. So I'd like the committee to look at that and consider this Title 14 is what governs the probate court. Title 18 governs the family court, the district court. We can combine those into one. That would be perfect. Because I don't really think when you see the differences, there's 14 differences between 14 and 18, that we need both.
In your research, did you get any information as to why the involuntary guardianships are originating in family court as opposed to probate?
Well, a lot of people can't speak for themselves, number one. This individual had somebody that was advocating for her. And basically it's, if they're, not capable of governing their own, and this could actually spin over, I didn't, God, my constituent for saying this, but not only does this affect people with mental disabilities, but it also could affect people with dementia, and that don't have anybody to advocate for them. They could, if they actually went through the probate court and had somebody willing to be a voluntary guardian, that it would be a good thing.
Well,
So I hope I explained that. I'm shifting gears, but I didn't get my sleep last night.
No, not a problem. So, yeah, just wanted to, that provides a general overview of it, and I think we will get legal counsel in to, provide us the walkthrough and the legal details on it, and then we can take it from there.
And Barry Fitzpatrick did actually got the scenario. He's very familiar with the case that I was speaking about, and he's dealt with this bill last biennium that was estimated. So,
Well, thank you.
oh, I appreciate you hearing me out. Have a good day.
Yeah, you as well. So we're a few minutes ahead of schedule, so we can just switch gears to S7. It's Maria is not in here, right? Is Maria coming?
Who's coming out?
Oh. Well, before we start on that, any thoughts on Terry to Senator Williams' bill? I know we didn't get much detail just because we were just overall walkthrough, but we can also just wait until ledge council.
Yeah,
Would be helpful.
Yeah.
I wouldn't mind learning a little bit more about the guardianship there.
That seems good. All right. Well, in that case, we can switch gears to S7, and I'm sure Maria will be here any minute. So S7 was a bill that we passed out last year. I believe it was unanimous in this committee. I can't remember if it was unanimous on the floor. I feel like it was. It was close. And so, this was, long story short, it is, in my opinion, a bill that would require insurance companies to pay their policyholders what the policyholder expects to receive from that insurance company based on the premiums that they're paying. I know that some of the witnesses that we have will be able to provide a better understanding of why that does happen and why it doesn't happen in some instances. But in my opinion, it's a pretty straightforward bill. Fortunately, it did run into some challenges in the House and didn't make it out of there. But my hope is to kind of just pick up where we left off last year, get it back to the House, and perhaps they will choose differently moving forward with it. So I think if Adam, if you're ready, we can have you go, and then we can have Maria do a walkthrough. Because I think everybody in the room, aside from Senator Matos, is pretty familiar with the bill, and it's fairly straightforward to pick up once we get the walk.
Is this ultimately the same bill we passed?
Same bill that we passed. I believe it doesn't have the subrogation piece in it, if I'm remembering correctly.
It does have the
Does
segregation.
have.
What it doesn't have is the increased limits.
The increase, okay, yes, that was the piece I was thinking. Thank you.
And I can talk about
Thanks. Take it away.
Okay, Mr. Chair, members of the committee, Adam DeCrasson, the DeCrasson Group, Vermont Association for Justice. Appreciate the opportunity to be here and to kick off this legislation. We have here with us today, Kristen Ross, who's kind of an expert in this area, and maybe after Maria, she can come up and just kind of the warm-up setup overview. Actually had, and I can defer for the moment if you prefer a walkthrough or you want the orientation.
That would be good if we could defer to Life Council, because I'm sure they're on a super tight schedule as well. But thank you, Adam.
Good morning,
Good morning.
Maria Royal, Legislative Council. I'm sure Adam would have done a great job walking through the bill. So now you have to suffer through my walkthrough. So I believe you all have a hard copy of S7 as introduced. This will be familiar to some of you. It's essentially a rerun of S150 that was taken up last year and passed the Senate. This is the language that was passed by the Senate, so it was amended in this committee. This reflects that language. It went to the House. House Commerce took it up, never got voted out. So the bill concerns automobile insurance, and specifically underinsurance coverage and medical payment coverage. So we'll start with section 1, which is underinsurance. So as you all know, in Vermont, you are required to have minimum liability coverage to protect yourself if you're in an accident and you're at fault. In addition to that liability coverage, you also have to have underinsurance or uninsured motorist coverage. And that's protection if you're in an accident with someone else who is at fault and they either don't have insurance or they don't have enough insurance to cover your damages, or if you're in a hit and run and there's no policy. So in section 1, with respect to underinsurance, what this does, it doesn't change the amount that you're required to have for bodily injury or death. What it does, if you look on page 2, where the substantive changes are, I'm going to tell you what it does, and then we can look at the language, because it's kind of confusing to just look at technical language. Right now in Vermont, you're in an accident with somebody who is at fault, and you're insured, you collect damages from the at-fault driver, but it's not enough to cover your injury, so they're technically underinsured. They don't have enough to cover your damages. Your insurance company, your policy that you purchased, will kick in to provide coverage, but what happens now is whatever coverage you received from the at-fault driver is deducted from your underinsurance policy, and the difference is what's available to you. The proposal here is to say, irrespective of any money you received from the at-fault driver, you get the full amount of your underinsurance coverage. There's more money available to the injured party. So that's the proposed change. Different states handle it differently. both ways. So it's a change to Vermont's law. And so if we just want to look at the language on page 2, line 1. So this is what it means. The definition basically of underinsurance. So the liability insurance limits applicable at the time of the crash. So that would be the at-fault driver, their insurance, are less than damages that a person insured pursuant to this section is legally entitled to recover because of injury or death. So the amount of money you collect from the at-fault driver's insurance policy is less than your damages. 2 is similar, but it's just if it's less than because it's paid out to different people. And then subdivision H on line 10 is very specifically what the new standard would be. Payments made to an insured party under the liability insurance policy of the person legally responsible for the damage or personal injury, so the at-fault driver, shall not be deducted from the underinsured motorist coverage otherwise available to the injured party. So that's the substantive change. Section 2 of the bill concerns medical payments coverage. This is optional coverage in Vermont. And basically what it does, if an insured wants to purchase additional protection to cover any medical costs that might not be covered by their health insurance, for example, that might be co-pays or deductibles. It's usually small amounts of money, but that money is available immediately to the motorist or passengers in the vehicle, regardless of fault. So usually small amounts of money available to cover any of your medical expenses that are otherwise covered by your health insurance. So the proposal here with respect to that optional coverage, starting on the very bottom of page 2, where it says, however, with respect to that coverage, on page 3, the right of subrogation against any third party shall not exist or be claimed in favor of the insurer who has paid or reimbursed to or for the benefit of the insured medical costs payable pursuant to medical payment coverage. So what this means is you're in an accident, you pay for the coverage, you have costs, expenses, deductibles, whatever, your insurer provides that coverage to you. What this is saying is your insurer did not stand in your shoes and had your rights to go against an at-fault driver to collect reimbursement for that coverage. And so you'll hear more from the interested parties about what the issue here is, but just for clarity, I think part of the concern is there may at times be a limited pool of money that an injured party can collect. And because an insurance company can collect some of that money from the at-fault driver, it might mean that there's less money available to the insured party. So I think that's part of the debate about this issue.
So I think 2 years ago, we did a bill that got this sort of what was allowable for an insurance company to collect from damages specifically around hospitals. Would that be something we could do in this case where we could sort of limit and say the insurance company can only take X percentage?
Possibly.
Okay.
Possibly. I'm not familiar with that, but yeah, if this is saying they don't have that right to collect anything.
To collect anything.
You could-
Okay, I'm just wondering what the avenues and options are.
No, that's possible.
Okay.
And so this would take effect on passage, but it would apply to insurance policies that are offered, issued, or renewed on or after January 1st of next year.
Thank you.
Okay.
Any other questions in the finish? That's great. Thank you for your time.
You're very welcome.
Okay, thank you. Adam McCracken Group, Vermont Association for Justice. Appreciate the opportunity to be here and to run you through I'm here to kind of give an overview and then, hopefully you can get more details from Kristen and then in following hearings from some of the other folks. My testimony is kind of guided by a transcript we have in Senator Sears' floor remarks, so I'm just going to kind of follow that as my guide. Appreciated his leadership in this area and, really miss it. Okay, so where are we? The aftermath of a motor vehicle accident. This is not your basic rear-ended whiplash, bones have been broken, you're out of work, your life is pretty screwed up. Someone crossed the center line, texting and driving, a drunk driver careened into you, and your life is in disarray. It's a bummer, you didn't deserve it, and you are not, even with this law passing, going to end up ahead. I just want to start at the end. This is about minimizing the injustice in an era of a time when medical bills are eating up the little insurance that's out there. Okay. So we're in the aftermath of a motor vehicle accident, two narrow ways to adjust the law so that innocently injured victims can get more value out of their own insurance. So this whole bill where you guys write the fine print, because the law is the provision that determines the fine print in this case, is on insurance I bought to protect myself and how it's going to reconcile that. Your work on this bill was inspired in the last biennium by a fellow Con Dinsmore, refreshing your memory, and for he was on his motorcycle, got hit by a drunk driver crossing the center line on his way home. A fellow who, was a short haul truck driver, life in disarray, loss of limbs. And, he came to you and testified about his story, which was very hard. He was re-traumatized, it's a re-traumatizing experience to come and tell, but he really came and sat here and said, I don't want this to happen to other people. I bought insurance and I didn't get what I thought I deserved. Kristen will bring some other stories because we kind of went out in the meantime and kind of collected some more. And we can bring people in, but it's a big ask. And so we're hoping to convey their stories. Maria explained provisions. Kristen can walk you through them. I'm staying at the super high level here. But the underinsured motorist coverage is the part of your insurance that you buy to protect yourself from being hit by someone who has low insurance. And come to find out, there's two types of underinsured motorist laws: gap and floating layer. Right now, I'm on to gap stage. Right, I bought, for example, $100,000 in insurance, underinsured motorist coverage. Turns out that's up to $100,000 in recovery because the law allows deduction from the at-fault driver, the tortfeasor, the bad driver, the person that hurt me. Whatever their money pays in is deducted from mine. A bunch of states have the floating layer. And that's what this would change Vermont to. So, collect from the bad driver. And then if your damage is warranted, not just because you bought it, you could get the full value of what you purchased, $100,000, for example. The MedPay coverage provision was explained on the floor. Legal term for a law that allows your own insurance company to put a lien on your eventual settlement. It covers your medical bills right away. Think you have a $5,000 deductible on the insurance you have from work, and you're actually in an emergency room and they want money from you. So you have this MedPay provision. We all probably check the box and buy it. It's optional to immediately pay those bills. And, this bill would allow you to keep the recovery when it eventually settles. Section 2 prohibits the subrogation of MedPay coverage where your own insurance company is allowed to put a lien on your eventual settlement. This provision is like the law in New Hampshire, where MedPay subrogation is prohibited. So in essence, it would make sure that you're not buying an insurance benefit to pay back your own insurance company. The effective date, you worked on this last year, January 1, 2026. This wouldn't, the way you amended it before you sent it out of committee was so that there would be a lag, so that all the policies in place would be as they are. It would be for new policies issued starting sometime out in the future. So the goal isn't to impact current policies in any way. All right. The top lines that were noted on the floor. Vermont is among the lowest overall auto insurance premiums in the country. This does not mean they're inexpensive. I'm not here saying car insurance is cheap. It does turn out that the underinsured motor is part of everyone's coverage. The amount you pay is like 10% of the liability share. It's very inexpensive. So rate pressure, if you hear about that, you may, from critics, is in a very small part of your bill. Very small part. The reality for everyone, the increase in healthcare costs, increasing cost of living makes it very hard to, when you are hit, to even have any money left over for you. You've got major medical bills and they're in line kind of ahead of your pain and suffering.
Senator Polsky has a question.
Yeah, I do. So given that, the number one cause of bankruptcy in this country is in fact healthcare costs, I wonder if you have any sense of what percentage of those healthcare bankruptcies are driven by accidents like this?
We'll look into that.
Okay.
Okay. Do know that this circumstance you'd be impacting is a narrowly occurring, but dramatically traumatic for those affected by it, right? You've got to, and so this isn't every car accident. It's ones where people are pretty messed up. Okay, fine. Where are we in the insurance market and why are we in the judiciary? Well, it's in your jurisdiction for a couple of reasons. Again, you write the fine print, but this is a certain type of insurance that we're dealing with here. This is not your nonprofit Blue Cross Blue Shield, premiums paid in, go back out to claims. This is the most competitive for-profit sector of the auto insurance market in America. When you watch a major sporting event, the unifying American experience, every other ad is a jingle that we all could recite right now from 5 major companies. So when they're setting their premiums, they want them to kind of match payouts so that they can take those premium dollars and make tens of billions of dollars a year in earnings on the premium dollars. So this is a wholly competitive market. And so I'm here to say at the very end of this, that the Judiciary Committee's judgment last year was this little tweak in the law is going into a big competitive for-profit insurance market. We're light touch on that today, but Berkshire Hathaway and Geico are reporting increased earnings. And we're here to say this is the most spelled provision you could find to get more money at the table for people who are innocently injured. In the bill last year, as introduced, but now when it left the committee, increased the mandatory minimums. That leads to a conversation about lower wage workers buying minimum insurance, increasing the cost on them. And so this was a compromise to say, well, let's find these 2 small changes that can kind of help adjust to the cost of living in a way that doesn't kind of raise the government's demands of you to buy more insurance. So refreshing your memory, this was a big compromise in that regard. We welcome the opportunity to follow more. Kristen's the expert. Appreciate the opportunity to handle what they're heard.
Good morning. Nice to see some of you again. I was here last year. Hi, Senator Mattos. I know you're new to the committee. I came last year and brought my client Condon Moore, who Adam just referenced. So I just sort of wanted to, and I apologize, some of this might be a little bit duplicative, but just to remind folks, and for you, Senator Matto, who might not be familiar with some of these issues, there's really 4 types of, I didn't even introduce myself. I'm Kristen Ross. I'm president of the Vermont Association for Justice, and I have a bi-state practice, and I represent seriously injured Vermonters.
And the concern that I and many of my colleagues have is that we have an issue with folks being underinsured in Vermont. We have an issue with not everybody having enough insurance coverage. And when somebody is seriously injured, there is just not enough money to do anything for those folks. And it happens a lot. And we're seeing a lot of folks end up on public benefits as a result. And we're trying to make some changes in the law so that folks can get more of the benefit from their insurance coverage, okay? And just to be clear, there's 4 parts of every insurance policy. Liability coverage, that's what everybody thinks about when they think about insurance. That's not what this bill is about. Property damage coverage, you back into a tree, that's not what this bill is about. It's the other 2 parts. Underinsured motorist coverage and MedPay coverage, okay? Underinsured motorist coverage is somebody hits you, you're seriously hurt and there's not enough coverage, you've got to turn to your own policy. And then the other is MedPay. MedPay is $1,000, $2,000, maybe $5,000. That's the amount of typical MedPay policies. We're talking about a really small amount of money. The problem, and I'll come back to the underinsured motorist coverage, because that's really the heart of the bill, is changing our law so that folks can get full benefit out of their policy. But the MedPay issue, really, this is what it comes down to. Right now, if you're injured in Vermont, let's say you have a typical health insurance policy with a $5,000 deductible, right? You go to the emergency room, you're going to owe the first $5,000. Well, you've paid for under your Vermont insurance policy MedPay coverage, and if you've got $5,000, it's perfect. You can use that to pay your deductible. Okay. The problem is, fast forward down the road, if the injured person gets any recovery as a result of that crash, they have to pay back the MedPay coverage to their own insurance company. That's what we're just trying to fix. And when we say subrogation, all that means is just a fancy way of saying a right to be paid back. All we want folks to do is, if you've paid for MedPay coverage, either $1,000, $2,000, $5,000, you've paid a premium for it, and you have to use it, you shouldn't then have to turn around and pay it back. That's what we're asking to fix the MedPay subrogation aspect, okay? The underinsured motorist change to the law. I brought Con Dinsmore here last year because it was just such an obvious example of why the law is a problem the way it is. And Con was, like Adam said, Con was hit by a drunk driver and ended up having to have 15 surgeries and was a double amputee. And he lost his career. So his damages were millions and millions of dollars, right? But there was only $300,000 in insurance coverage that was available. But under the way the law worked, because of this automatic deduction that we're trying to fix, Con's $300,000 potential recovery automatically got reduced to $200,000. And it was just such an obvious example that somebody like Con should have been entitled to all $300,000. The problem, I think, and this maybe came up in the House, was with me bringing Con, where it was such a horrific example. Some folks had the misimpression that maybe this is just something that happens only occasionally, and unfortunately with somebody like Con, there's nothing that we're ever going to be able to do to fix that situation. So maybe this isn't a problem that regular folks deal with. I'm here to tell you that's not true. Every single day, me and my colleagues have folks come into our offices in Vermont who are seriously injured. And by that, I mean surgery, broken bones, out of work, and we can already tell if there's not going to be enough insurance recovery based on this automatic reduction. And so I reached out to my colleagues in anticipation of coming here, and I just said, hey, look, can you guys, I brought Con, but can you give me some examples of some other folks in Vermont that you've represented over the last few months with similar stories? And I got a list. I got Elena, who is a Vermont resident who shattered her pelvis. There was $150,000 in insurance coverage. Her medical bills were well in excess of that. Her recovery automatically got reduced because of this automatic reduction. Amber,
How much did it get reduced by?
in Elena's situation, in this particular situation, the person who caused the crash had $100,000 in coverage and she had 50. Because of the automatic deduction, she wasn't able to get anything from her $50,000 policy, and all she got was $100,000 when there was $150,000 to get. Amber is another example. She had a broken neck, broken arm, medical bills of $187,000. There was $150,000 in insurance coverage. I mean, in this situation, we're talking the med bills alone are more than all of the coverage. We're not talking lost wages. We're not talking pain and suffering. Even though there was $150,000 in insurance coverage, Amber could only recover $100 because of this automatic reduction. So, to be clear, we are not saying that folks should get extra money for damages that they're not entitled to, or they should be able to get money from the at-fault driver and then double dip with their own insurance. That's not the situation. We're talking about catastrophic injuries where clearly the damages are worth more the coverage. And in those situations, you just shouldn't have this automatic reduction for the tort fees or credit, meaning people should be able to get the full value of what they're paying for under their policy. That's what we're trying to fix. Does that make sense?
Yes.
Okay. And so I have other examples I can go through with you for other folks, but I just wanted to make sure that you guys didn't have this impression that Condensmore's example was unique or not something that happens all the time in this state, because it does. And unfortunately, most people don't have enough insurance coverage. And when you're seriously injured, we just try and do as much as we can for them to help. And this would be make a big difference in how we can help everyday folks whose lives have been ruined for nothing that was their fault.
So just so I understand the sort of difference between, and I actually think you might have been slightly involved in the hospital
I was.
bill as well.
I
So
did.
yes, so the difference as I'm understanding it is the hospital leans and allowing them to take a small percentage that they're paying for actual costs incurred, whereas the insurance not being allowed to subjugate at all is because someone has paid for this service and there are no actual costs.
Exactly. And so
Thank you.
And just to clarify, so the hospital lien issue, what we needed to fix in that was that under Vermont law, when somebody was in a crash, they didn't have to bill the available health insurance. They could instead try and pursue the claim, and there was a whole bunch of reasons. And so this said, yes, if you're a hospital and you owe money, you're still going to get paid, but if there's insurance, you got to bill it, because we're trying to limit situations where we've got folks who are filing bankruptcy because they've got hundreds and thousands of dollars of medical bills, or moving on to public systems, especially when there was health insurance to bill. Yeah. And so in this situation, you're right. The med pay, limiting the med pay, you can think about it as a clawback, a subrogation right to be paid back. It's just a small amount of money. That's really important. And you pay for it.
The service you pay.
Yeah, it's like, what's the point of paying for it if you get penalized for using it?
Yep. So it's like paying for a loan that you're gonna have to pay back.
Exactly.
So, yeah.
Exactly. And so, and on the ground, that med pay, limiting the med pay subrogation, that's going to make a difference in every single case, even smaller cases, because just folks who have to pay back that $1,000 or $2,000 or $5,000 when they needed it for medical bills, that's a big financial burden.
If you could, either on a hypothetical example or with one of the real world examples that you have, can you just provide the timeline, the step-by-step process in which people end up with these outcomes that you've described, and what happens where, who takes what, and just what that timeline looks like?
Sure. So you mean sort of like the life of the case, kind of like okay.
Yeah.
So let me just give an example. So somebody might come to me having been in a crash and they were seriously hurt, and let's say they're 3 weeks into the situation. And the first thing that I'm doing is looking at, okay, how did it happen? Who is the at-fault party? And what do they have for insurance coverage? Okay. Unfortunately, so in Vermont, insurance is required, but a lot of folks buy it to purchase a vehicle and then don't pay the premiums, or they pay for the smallest policy that you can get, which is $25,000. You take one trip to an ER and you can eat through a policy like that. Okay. And so one of the things I have to first look at is how much insurance is there for the at-fault party? Am I dealing with a $25,000 policy, or is it a $50,000 or $100,000? Those are the most common. $100,000 is the most common policy limits in Vermont. Or is there more coverage? Okay. Then you have to look at what does your own client have for insurance? Do they have health insurance that can be paying these bills until there's a settlement? Is there med pay coverage that can help cover out-of-pocket costs? And is there additional underinsured motorist coverage? Because if I've got somebody who comes into my office with 3 broken bones, a surgery, and they've been out of work for 3 months, and they've got medical bills of $100,000, I can immediately tell in that situation that there's probably not going to be enough insurance coverage. And that happens all the time. And so what we have to do is we have to get, let's say there's $25,000 from the at-fault party. Let's say your client has $100,000. That's the most common amount. Your client's coverage is automatically reduced by the 25,000. So now you're down to 75. So you've got a total of 100,000 that I can get for this very seriously injured client. Out of that amount of money, all your medical bills have to be paid back. Your health insurance, if they paid anything, they have a right of subrogation, has to be paid back. Right now, med pay has to be paid back. Then if your client was out of work and got short-term or long-term disability coverage, that has to be paid back. There are so many insurance companies that will pay out in the first instance, but then have their hands out for money that by the time a poor injured person has this 100,000 and everybody has taken their cut, you have nothing left for the injured party. And so we're trying, and as attorneys, my job is to negotiate with all of these folks to try and get them to take as little back as they can so that my person can actually have something to compensate them. And so that's what we're trying to fix. Does that answer your question? Okay. You're welcome.
Get that out for the question.
Question, and maybe for you, it may also be for Maria, and that is when is the last point in time that we updated those insurance amounts? Just, I mean, healthcare costs have gone through the roof.
Yeah, this came up last year because as you will recall, so last year when we came to this committee, we'd asked for 3 changes to the law. We'd asked for this issue of fixing underinsured motorist coverage so you can get everything you paid for, getting rid of this, you got to pay back med, and increasing the insurance minimums from right now. The minimum amount of underinsured motorist coverage is $50,000, and we wanted to push it up to 100,000. The last time they had gone was in the 90s. Yeah.
It just, and I know that that's not in the bill this time. It just seems like, given the change in landscape of healthcare costs and change in landscape of sort of the economic reality that, 34 years is a perfectly reasonable time to consider updating some of those numbers. So I'm just a little curious why it's not in the bill, and maybe you can answer that. Maybe you can't answer that.
It was I'm sure what you're gonna hear from our good friends from the insurance side is the concern over increased costs and premium costs. And so that was a major concern. It has been a major pushback from insurance companies anytime we try and make changes to the law. But here's what I will say. We know we've got a system that is not working great for seriously injured folks in Vermont, and we're at least coming to the table with some real suggestions to make real change. And the idea that we can never do anything because, the insurance costs are going to go up. They go up anyways, whether you make changes or not, and they have continued to go up. And so certainly from our perspective, we would like to see an increase in the minimum insurance requirements in Vermont. Frankly, to be blunt, it would be really helpful if folks were required to show proof of insurance every year when they register their vehicles. Because the reality is people don't maintain insurance coverage in Vermont. We've got more folks in Vermont are uninsured than they are in New Hampshire, even though New Hampshire doesn't require insurance coverage, believe it or not. We've got a problem in the state. Here, the concrete ways to fix it. There is a lot more that could be done. There's a lot more that could be done. And certainly if you folks wanted to reconsider putting back in an increase to the minimums, we would be supportive, absolutely. It was just a part of the negotiations last year to get it through the Senate, frankly.
I seem to recall the increase in cost was rather minimal, around the range of a few dollars.
It is. And actually, Senator Matos, you missed last year when we were going through this. I think Senator Sears pulled out, he was participating from home. He pulls out his deck page and he said, he was like, well, how much is this? And so I walked through his coverages with him. them. And what Adam referenced on every single bill that you get for your insurance, you can see they charge you liability is what everybody thinks about when we think about insurance. That's you cause a crash, you're a risky driver, they charge you more for that. That's the bulk of your premium is based on liability coverage. This doesn't have anything to do with that. There's a small amount of premium for underinsured motorist coverage. I want to say, it was $13 was in Senator Sears's bill that we looked at. It was
Very
it's
small.
very, 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 very small. And I'm sure you're going to hear from the insurance folks, well, if you make this change and this goes from gap to floating, that's going to be a bigger charge because it's going to change the risk, meaning insurance companies are going to have to pay out more if this change goes through. That is the reality. They will. Okay. But you really have to put that into the context of how much is the premium for this type of coverage and what's the real facts behind that threat, because they go up no matter what. So it is these two types of coverages, MedPay and underinsured motorist coverage, these are a really small portion of the premium. So we're just not worried about that. And frankly, when you ask somebody who's seriously injured, anybody would have much rather paid an extra $10 to have coverage that means something than be in a situation where their lives are. Absolutely.
Yeah.
We're really talking about a small amount of money for a big benefit.
Thank you.
You're welcome.
Okay. Now, would this apply to commercial insurance too?
Yes, is the answer, because I'm gonna try not to get into the weeds on this, but you're an insured under, it's gonna apply to anybody who's an insured under a policy. And depending on how the commercial policy is written, sometimes the insured is the named individual. So you could be a solo electrician, right? And you're gonna be insured under your commercial policy, as is gonna be other folks in your household. You might have a commercial policy that's written differently and insures owners or operators, but to answer your question, underinsured motorist coverage is a part of every single policy that's written in the state of Vermont. And so any policy that has underinsured motorist coverage, you would be able to get a better benefit out of it.
Okay.
Yeah.
So like in my case, I have a business that's not in my name.
Yeah.
And then I have a commercial insurance for that, and I have other drivers on
Yeah.
it and things like that. That'd be totally separate from anything personally that I have.
Yeah, it would be. But you know what this would do is if one of your employees was out working and was hit by somebody and was seriously hurt, this will allow them to recover more under your commercial policy that you've been paying for than they can currently recover now.
So it would apply to both lines.
It would. Yep. Any other questions?
No, I don't think so.
Thank you
Thank you
very
very
much. And certainly, if anybody needed to hear from Juan again, I know as Alan said, he would come back. He did come last year, and I think we have his testimony if anybody wanted to be refreshed with it. So
Thank you.
yeah.
Next up, we have Mr. Feehan.
Morning.
Morning.
I'm first time with the session, Jamie, I'm Government Relations Director with the Vermont Eggleston and Kramer. I'm not an attorney. I don't usually set up, but this is the Judiciary. I'll say that I might as well have built by a close against. I'm here this morning on behalf of two entities, the American Property Casualty Insurance Association. APCIA is the preeminent national trade association for, as you might imagine, P&C companies providing all lines of insurance, from homeowners to auto to workers' comp to commercial, both types. Collectively, APCI members probably write about 65% of the Vermont market. That's consistent with what their market share is nationally. Also here this morning on behalf of State Farm, which is the nation's largest auto insurer, and they also have a significant market share of policies in Vermont. Thanks for the invitation to comment. I did provide some comment last year when this bill was considered by this committee. I'll just briefly restate the provisions that I'm going to speak to and that cause concern for us. Section 1 has two separate amendments, but nevertheless connected. There's the revised definition for underinsured motorist coverage that is being changed. And then, as you've heard repeatedly, there's the ability or not for an insurance company to deduct monies received from the at-fault driver in an underinsured motorist payout claim. The third is unrelated to that issue, and it's the inability to subrogate medical payments, which is currently allowed here in Vermont. And almost all of the in one jurisdiction in the country, most that's we strongly oppose each of these provisions, and I'll explain why. First, just you've heard a little bit of background, but perhaps from our perspective, a little bit of the background as well. We all know Vermonters are required to carry auto insurance. It's required by law. There are minimum requirements for this bodily injury, not what we're talking about here on the insurance, but we are connected and explain later. You've heard the numbers 25, 50, 25,000 for one person, 50 for two or more. So that's to protect yourself from bodily injury, damage, etc., medical bills. Yet Vermont are required auto insurance, but then leaves it up to the individual to decide how much insurance do I want to carry, how much do I want to pay, how much do I want to carry one for, and they're free to choose whatever that limit is, as long as it's equal or higher than the limits set in statute 25, 50, 10 is the minimum limit for property damage. There's also a requirement for what we're talking about today, underinsured, uninsured motorists. That's $50,000 for one person, $100,000 for two or more. There's also a unique Vermont provision, and this is important, that says if you carry BI limits, the first number is 2550, higher than 5100, your uninsured, underinsured limits will track, will share with those BI limits, so they'll remain the same. So this is also the underinsured. There is also up to the policyholder to decide how much insurance they want to cover, as long as it is above the minimum limits. Underinsured motorist coverage was developed decades ago, designed as an alternative to compulsory liability insurance, so that financially responsible persons could protect themselves against someone who has no insurance or is underinsured. You heard the phrase earlier, it's replacement coverage. You hope you never have to look to your own insurance to provide coverage for someone who doesn't have insurance or is underinsured. In essence, what you're doing is, when you're choosing how much you want to have for underinsurance coverage, you're putting yourself in the shoes of that other driver. You're saying, how much do I want to have for insurance coverage if someone doesn't have enough or any insurance coverage at all? So if I choose 100, I normally know here's my insurance coverage for underinsured motorists or uninsured motorists. If I choose 500, same thing. So you're again hoping you're not going to access your policy for this. You're hoping that the at-fault driver is complying with Vermont law, has insurance, and hopefully has adequate insurance. Much has been said about the limits. I wasn't going to talk about the limits today, but if you come back and do that, but several years ago, maybe it was years ago, the Department of Financial Regulation surveyed or study on the minimum limits in Vermont, and how many people were at the true minimum, how many had higher limits, and then again, I'm not speaking to it, but I can sort of paraphrase. My recollection was that about 7 or 8% were at the minimum limits, with the vast majority, 78% or so, around 100, 300, as opposed to 25, 50. I don't know if they've updated their numbers or not, but it might be interesting to hear, where Vermonters are on those limits, because what we all want to prevent or mitigate is the number of uninsured motorists on the road. Right, because that's what we're talking about. That's what's creating the problems. So back to the nature of uninsured motorists. It is different than the bodily injury first. Your own injury first party claims. It's the replacement that kicks in. That you're hit by someone who doesn't have insurance. So if the negligent driver is uninsured and has no liability insurance to adequately compensate the victim, the uninsured motorist coverage kicks in and pays whatever that damage is up to the limit. So in other words, If there's no insurance, there's nothing to, resolve with your policy up to the limits, and there's the coverage there. If the negligent driver is uninsured but they have insurance, but the limits are too low to adequately compensate for the damages, then you look again to your uninsured, underinsured motorist coverage to kick in and pay the difference for that. So if you purchase $500,000 in UIM, and the damages you have, you're going to get $500,000. And you remember, I chose $500,000 for my coverage. You will get $500,000 if exceed $500,000. What is currently allowed today is for an insurance company to go to the at-fault driver, and if they do have insurance, but it's less than the 500, company can then deduct from its own payments that amount received from the at-fault driver. So that properly assigns accountability to the at-fault driver. It also helps to keep rates low for you because there's that opportunity to offset the damage.
Just wondering if I'm understanding it right, but if we made the change, there would still be accountability, assuming the injuries were high enough, because you'd get from the guilty party and you'd also get the full value of it. Right?
I don't know if I would use the term accountability in that instance because, again, the individual in my example chose 500,000. Let's say the at-fault driver had 250.
Yeah.
In today's scenario, the injured party still gets $500,000, but my insurer gets to deduct the 250. So under the bill, there's 750,000 probably going.
Right.
The damage.
And so as I understand it, it would only be 750 or up to the necessary limit for the injuries. So we're just creating a higher ceiling for repayment of the injury, the actual injury. But to your point about accountability, it wouldn't get rid of accountability if we made this change. You would still have the other person's share.
That all driver would still be contributing to the overall plan.
Yeah.
But my own insurance company would be contributing more than it currently
pays your company, not their company.
Right.
Well, I just want to say, so just to clarify though, the insurance company that has the $500,000 policy would be paying the policy, the full amount of that policy, which is what the policyholder has been paying the premiums into, right?
It's part of the overall premium. Correct. Right. It's also calculated though, I'll get into this further, based upon the potential exposure that the driver faces. So insurers are no doubt calculating today the ability to utilize that offset in developing that premiums.
Senator Most.
So when I pay my auto insurance policy, I'm paying, to Senator Burr's point, my auto insurance policy to pay out $500,000. I'm not paying my auto insurance policy to pay out some percentage of that based on what someone else's coverage might be. That's what they are paying for. So to me, it makes perfect sense that it would be additive because what I'm paying for is my auto insurance company to pay out $500,000.
And they do.
Assuming that the injuries mentioned.
Right.
Right. But you say they do, but they only do if the circumstances work out that they have to. But in many cases, they don't because they subtract the other company's contribution.
There's the ability to offset. Correct. Yeah. And again, I don't know, it's unique. It's underinsured motor. Yeah, that's different than the 2550 BI limits. Again, this is replacement coverage. It's what you expect. You're putting yourself in the shoes of the at-fault driver, what you anticipate or would like to get for insurance coverage. It's 500. It's there because it does prevent against double recovery, two payment for the same injuries. It does, the nature of underinsurance motor coverage is not to put you in a better position, to put you at the limit that you procured for insurance.
Quick question. I know we've gone through this all before. Thanks for being here. So it's nice that I have the ability to choose $25,000 policy for uninsured motorists. If they don't have it, you give that to me, or the insurance company gives that to me because I chose that. But if I choose to go with a $500,000 policy, correct me if I'm wrong, okay? And that's what I've chosen from the insurance companies, that's what I should be paid. But as it exists presently, so if the other motorist who was at fault in this accident has a $250,000 coverage. I'm just trying to simplify this, okay, in my mind, so you're gonna give me 250 because they gave me 250. However, if my medical bills are $600,000, who's gonna make up that $100,000 when I have $500,000 policy to cover that additional cost? So is that now on me?
It's above the limits of insurance policy, so it's not.
But you took $250,000, the insurance company took that from me. I'm still looking at probably like injuries are gonna last the rest of my life, and I'm looking at $100,000 now that I'm still gonna have to absorb when I have $500,000 policy. So that doesn't add up, and I don't think 9.9% of people out of 10 know this, because I didn't know until last year to be honest. So it's great that we have insurance. And I need insurance companies to be there for me. I need them to flourish in what they do. But I still need to live in the interim here. And that doesn't quite seem, in my opinion, I'm not speaking for the committee. Fair. And that's all I'm saying here.
I think, we were all educated on this one last year. I was in that camp, and it did, highlight for us in the housing committee focus on this a lot as well. What can we all do better when procuring insurance and understanding the policy and what's behind the choices that we make in terms of how much on the insurance, uninsurance can be covered by the line of care and protecting it in that and recognizing the choose of millions and choose of 100,000, but it is insurance.
Senator Meadows, did you have a?
Yeah, I'm thinking about it. If I'm going to purchase automobile insurance personally, and from what I'm hearing today, I want my liability insurance to be at the minimum because it's the highest part of my premium, like it costs the most. So I want that to be at the minimum, so it kicks over into underinsured on the person that I run into. And on the flip side of that, I want to increase my uninsured, underinsured, because it costs less money on my premium. And say somebody like me that has the minimum liability, then my underinsured kicks in and I save on my premium. Is that kind of how I want to do my insurance then?
You're getting to my comments on the revised definition. Well, I'm going to turn to that if I can. Page 2, right at the top. This is changing the definition of underinsurance so that it's removing. The current law says, it's subject to the limits of the policy. And now it's changing it to not the limits, but the damages suffered. So we read that as to mean potentially. We don't know what the damages are going to be in an accident. So we read this to mean that the damages can exceed the limits of the policy. So to your point, why not carry the minimum? Because you're going to get full recovery up to the damages.
I would say carry the minimum on my liability side, but carry a $2 million underinsured because it costs less.
But remember, the price is calculated now based upon current Vermont law. So if we see a reaction for the bill that passes, I'll speak to this in a bit.
Like even if this doesn't pass, current Vermont law, a lot of people carry, say, what's a normal uninsured?
100, uninsured? Well, I think the majority, according to the DFR study, the majority of people carry 100, 300 or VI, so then the underinsured will track with that.
So say I carry that right now, nothing changes. It doesn't go anywhere. But I go to my insurance agent and say, hey, drop my liability down. So my insurance goes down, but take my underinsured part and send that to $2 million.
But will that not expose your own injuries? Like if you hurt yourself in a crash?
Well, the flip side of it, if I get into a crash and the person that has liability insurance maxes out at whatever their minimum is, and then it comes over to my side and now I say, hey, I got $2 million kicking around, pay that out. Wouldn't that be the way I want to do my insurance right now? Because it's cheaper to have that underinsured uninsured motorists.
I think your agent would advise you not to do that for, because you'll be personally underinsured for your,
But I keep it at the minimum.
yeah. You're
Yeah,
allowed
I
to
hit
do
that.
to them. Which,
I don't know, I'm just thinking now that I've heard from you and
Yep.
and the other side, I'm just, and how you hit those limits at the top and then you're left, like Bob's example, you're left with no money left on the table if I just increase that.
Sometimes you're in debt.
Yeah,
Yeah,
Right.
With, in the case we talked about with missing limbs, and no possibility of work thereafter in his chosen field. Mr. Chair, I'm not sure if I'm understanding you right, Jamie. I don't read this as to be saying that if we make this change, any amount of damages are covered.
Yeah, I had that same question as well.
Yeah.
we'd love to see some clarity because it really, damages are not defined here, they're not defined elsewhere. Right now, we know there's certainty because it's to the limits, but it doesn't say that, that it's still confined for the limits. The damages are still confined for the limits of the policy.
Well, but they're legally entitled to recover under the applicable limits at the time of the crash. So,
Like limits is legal.
well, another question that I have for you, and maybe it's a comment as much as a question, but it seems to me that whenever we talk about reforming insurance or very heavy profit industries, we're told that if we make any change that increases their bottom line or decreases their bottom line by $1, they're going to have no choice but to pass it on to rate brokers, and therefore there's a punishment in place for having legislated in that area. You're punishing consumers by doing this, and I just have to reject that logic. I don't understand why we can't say as a state, we find X practice, is inequitable for the people who are buying this. And we're going to reform it so that they get more of what they're paying. But then to have a heavy profit industry to say, go ahead, we're gonna recover the money one way or the other. It seems to me that's the worst of capitalism, where we're saying, no matter what you do or what's fair or what's right or what the person thought they were buying or has been told that they're buying, we're not going to be on the hook for any more dollars than we are now. We're going to raise premiums to the point where we're held harmless. And when I was in economic development, everything we tried to do, the affected business or industry told us, you're just going to make us raise prices to that extent. And I don't believe it, number one, but I also think that we have to fight against that and produce more equitable results from a heavy profit industry like insurance. So this seems to me very much in line with what every single person who buys a policy believes is going to happen. And it greatly reduces the possibility that you have people like Khan who are just basically out of work and out of luck when it comes to their insurance premiums and payouts. So not a question so much as
I may be wrong interpret that as a comment. I mean, and I think I mentioned this last year when we first looked at the bills introduced, which had the increase in volumes, and they saw common to the insurance companies said, why would you object to, people buying more insurance? But part of what we want to do, because it is compulsory, is to make sure that insurance is affordable for people, that they can properly procure what they can afford, that they're protected, but that we don't price them out of the market and therefore drive up.
right. But I'm speaking just to these changes, not because those aren't in the bill.
Sure. No, and
So these changes, I heard you saying, if we make them, insurance companies are going to have to reforecast and charge more to take into account.
it'll be up, right. It'll be up to each individual insurance company in terms of how they respond to this bill. But by allowing, the term I'm using is stacking, but by allowing stacking of the at-fault driver policy with your own policy, you do increase the exposure that is not currently contemplated in the auto insurance premium now. How insurance companies react to that exposure remains to be seen. Increasing rates is certainly a possibility. certainly the company has, significant market share in Vermont. The trouble with what the challenge with uninsured motorist coverage is that it's a wildly unpredictable insurance line. It will spike, it will decline. There's not great data on it. So it's really hard to model for something where you don't have consistency. All I can say is that when I spoke to companies about this, that premium adjustment is certainly on the table because of this increased exposure.
I mean, my question for you generally, the companies that you spoke to, can you describe what their profits have been like over the last year?
I can't, what I can tell you is companies have been losing money for the last couple of years. I haven't seen anybody making profits. And if you're like me, my auto insurance rates have gone up absent any claim activity. And the reason for that is it's, in short, inflation. I mean, insurers are paying out more in claims. They're paying more to repair vehicles. The value of vehicles and used cars has increased dramatically for the last couple of years, as has home residences, businesses, et cetera. So this notion of, profits, I think, I'd like to kind of go back and actually get some numbers if that's the case.
I mean, I'm fairly confident State Farm had a huge amount of profits. At least when the last time we were looking at this bill, I mean, it was through the roof. And I think they're one of the largest insurers for Vermont, right?
They are, yeah.
So, I mean, I'll go back and verify that and see how the last year has been, but table that for now. I think Senator Norris and Senator Bohovsky.
Yes, thank you, Chair. Just out of curiosity, I guess, and in all fairness, do you have any suggested language that you spoke about in reference to what's being proposed here?
Well, it's the ability to stack or not is an either or, right? So I don't think there's, I thank you for the invitation. Let me consult with folks and come back to you. Our preference would not be to revise the definition of underinsurance because, again, for the reasons there's ambiguity, or at least kind of tighten that up to make it clear that the damages are still subject to the overall limits of the policy and can't exceed it. So that's a simple phrase to kind of add in. I'll look to see if there's any, because as was mentioned, the majority of states are like Vermont and do not allow stacking, but for those that do, perhaps there's some language that might be considered. I haven't spoken to MedPay. I don't know if I could briefly on that. I don't know if there's another question on that.
Yeah, we've got time, but I think Senator Bohovsky had a question
sorry.
after Senator Norris.
So yes.
I'm
thank you,
okay
Senator.
for right now.
Please continue.
So MedPay is there. MedPay, turn my nose to MedPay. It is an optional coverage in Vermont. It's typically, a $5,000 or $10,000 add-on. It is available to the insured to pay for medical costs. You've heard the example, pay for deductibles on your health insurance policy. It's first dollar payment that is available to the insurer, to the policyholder, regardless of fault. So in other words, if you want access that insurance company is not going to determine, who's at fault or whatever, there's the immediate payout pursuant to the terms of your policy. Subrogation, I'm certainly no expert in subrogation, but it happens all the time. If there's a 4-vehicle accident right over here at this intersection, insurance companies will always, behind the scenes, usually unknown to the policyholder, confer with each other to assign, responsibility and then collect sums as it is. Again, it has accountability to the at fault. It also helps to reduce premium costs and overall payouts because there is this sort of collection and redistribution of money amongst responsible parties. I'm not sure what's unique about MedPay, but the inability to subrogate, again, potentially leads to double payment for claims. You could even go further because it is sort of a payment regardless of fault. One of the perhaps unintended consequences might be would an insurance company, perhaps not be so quick because they know there's the inability to subrogate and collect from the at fault party. And so does that add delay into settling claims? I don't know. There aren't a a lot of states, as I mentioned, I think New Hampshire might be one state in the country, this was the case last year, that prohibits subrogation of that. It's not one component of the policy. Again, these claims are small, but for public policy purposes, I understand why MedPay, you don't understand why MedPay would be treated.
So
Sorry, Senator Boski has her hand up.
Yeah, I was wondering, so we keep comparing to New Hampshire in terms of this bill, and I wonder if you have information on if the insurance rates are astronomically higher in New Hampshire than they are in Vermont. I mean, because that's sort of what we keep coming back to is if we pass this, the rates will be higher, but it sounds like New Hampshire does this. Are the rates higher?
Yeah, maybe that's a question for the opponents. Again, I brought it in because that's the only state that allows this, but they. And again, New Hampshire is also, you said, it isn't a compulsory insurance state, so I don't know if you can do an apples to apples comparison.
you said if we made this change, insurance companies might not be so quick to pay out a MedPay claim. Are you saying that they would adopt a policy where they were going to delay on purpose or not?
Not at all. I mean, but if the claim clearly has some sort of at-fault components to it, recognizing the ability to not recover, it may lead to some, hopefully it's not happening now. It's not going to be a conscious decision to adopt a policy.
I'm
Compromising.
just not seeing what would cause the delay.
Knowing you won't be able to recover from at-fault parties.
Right, but then it would be intentional. You would know, and then you would delay on purpose.
I can understand. I don't think there would be an intentional.
Okay, so probably not
the
the
same.
same.
Perhaps an unintended consequence.
Thank you. Any further testimony or?
Yeah, just on a brief bit on the effective date, and I appreciate January 1. So just as a reminder, if this bill passes in its current form, it's going to require some substantial work on the part of insurers and the Department of Financial Regulation. Changing the definition of underinsured motorists will require all auto policy forms to be changed and refiled for approval with the department. Changing the ability to not allow the offset for underinsured motorist claims also will require changing of policy forms for all auto policies with the department. And to the extent, the likely extent there is a reaction in premiums as a result of this bill, that also will incur filings with the department for rate review. And these are time, take a lot of time, a lot of resources, hundreds of policies. A company like State Farm has multiple policies alone for auto. I know it may not sound sympathetic, but it really is an undertaking. So we would ask that you consider July 1 to 2026 rather than changes. But again, our hope is do not move forward with this current conflict.
Mr. Chair, the original effective date was in the bill last year was, you remember?
I can't remember from last year, but I remember there was conversation regarding trying to make it coincide with when policies get renewed so that there's not the sort of backtracking, revise policies that are in place. So
Just perspective.
yeah. So, I want to know. Any other questions?
There's no standard renewal date for auto insurance like there is for health insurance. Is there like it's a rolling?
Right. It's either a 6 month or 12 month policy.
Right, but it's entirely dependent on when you sign up. So if I bought a car in September, my insurance would renew either in September or whatever is 6 months after September.
Right.
Yes, basically.
But this will trigger, again, the form requirements. So regardless of when we accept.
Yeah.
All the others.
Not that stuff from last year. I don't remember. Does anyone in the room recall the number from last year, the bill number?
That's 150.
That's 150.
150. How do we all know it?
January 1.
January 125.
Okay, thank you.
That's what's passed by the Senate. So the bill was actually introduced in 2023, even though you took it up in 2024. And the very original effective date was any policies effective, offered, renewed on or after July 1st of 2023. So
Oh, so that was,
so
But would
then
have
you
been
took it
effective
up
on patent.
on that, correct. But then you took it up last year, 2024, and you put the date,
Got it.
January 2025.
got it.
So we've already pushed it out from quite significantly, sort of what the original bill intended. Okay.
Any further testimony?
No, I will follow up, with Senator Norris's invitation to see if there's some, suggestions we might have, and appreciate that. And, certainly available and can try to expound on some issues.
Thanks. I'm also curious about, profits really, for these companies. And you know, what the last year or two have looked like for them. You know, any decision for these companies to raise their premiums as a result of us suggesting that they pay the full amount that policyholders are paying for. I mean, that's a decision by insurance companies. So my perspective.
It reminds me, a long time ago in the land far, far away called California, I was renting an apartment and my landlord came to the door and said, I'm gonna have to raise your rent. And I said, why? He said, because we had an inspection and your apartment's under code. And so I had to do this work to bring it up to code. So I'm gonna need to raise your rent by that amount. And I said, wait. Right now you've got me living under code at this rent. And then you're gonna raise my rent because you're bringing it up to code. And I feel like there's a similar kind of logic here that if we somehow get people what they paid for, it's gonna cost them more. And just doesn't seem equitable to me.
Right, I don't want me to retread around the end of. You will get the 500,000, right? Whether you get it with an offset or not. Is
Right. What I paid for was 500,000 from my company that I paid on. That's my way of looking at it.
Well, right, and the other person paid for whatever from their company, and so for that to be additive, given that both individuals have paid for those individual things, makes perfect sense to me.
Right.
You know, if I buy 6 oranges and my brother buys 2 oranges, we come together, we have 8 oranges, we don't still have 6. And I took oranges because I'm allergic to them, so of course.
So better there or less.
Exactly.
how'd you do with your landlord?
I don't, let's just say California has very protective renter laws, so, I rent statements.
Well, thanks for
Thank
the
you.
time.
I appreciate it. So I think we can adjourn here in a minute. And we can leave this up for a bit, wait for some additional information to come in and then revisit it in a week or two and take it from there. Is there any additional discussion, questions or anything before wrap up?
Just something quickly. I just thought it was, I didn't mean to speak on behalf of the attorney. I just thought it was fair as to offer them the opportunity to for suggested language. And getting back to the money portion of it, I think that I don't know if that's within our purview to ask for that specifically. I think that what it's going to show, if in fact they did produce it, was if we make this much money, this goes into effect, but we've lost this much money, we're still making this much money. So I'm not really sure. I think we know the end result, but we're still making money. Okay.
Yep.
So anyways, that you do as you best see fit, obviously.
Anything else? All right, we can